It only took a couple of hours after the Supreme Court issued their Dred Scott ruling. Their dreaded immunity ruling, before Trump's lawyers wrote a letter to Judge Merchan seeking permission to file a motion to dismiss for the criminal conviction in New York State. We're going to unpack the legal ramifications of that ruling and discuss how Democrats can mobilize right now to reverse it, to reverse the decision and to reverse the slide towards fascism that this country is taking. But first, a quick review. Yesterday, the Supreme Court issued its outrageous 6-3 decision that the President of the United States has absolute immunity for actions they take involving core presidential duties. Hypocrisy from textualist Federal Society judges is nothing new, but this ruling is as moronic and as far away from what is written in the Constitution as the Dred Scott ruling, and that's not hyperbole. The Supreme Court once decided that Black people are, indeed, property and not people. And now the current Supreme Court has decided that a president is a king, not a president. So right now, meteorologists are tracking Hurricane Beryl, or what they think is a tropical storm that has strengthened into a hurricane. It is neither. Those gale force winds that are howling at North America is the collective sigh and outrage of the founding fathers who are now witnessing from the grave the manner in which this Supreme Court has destroyed everything they worked to create, a system of government dependent on someone to preside over it for a fixed amount of time, and not a king. Well, kiss that dream goodbye. And the letter Trump's lawyers have sent to Judge Merchan is a clear example of how ridiculous this ruling is and how chaotic the implications will be. So let's unpack it. A jury of 12 random people sat in judgment of Donald Trump, and they unanimously concluded that he was guilty of all 34 crimes that the state of New York presented to them. And as you all know by now, the crimes involved candidate Donald Trump making hush money payments to adult film star Stormy Daniels in order to hide from voters that he had a sexual liaison with a woman while his wife was pregnant with their child. And here's where it gets interesting, because Trump's defense could have won this trial if only they had thought to argue that the money was not hush money, it was compensation for such a poor performance with Mr. Mushroom. If they had argued that, the whole case, much like Trump's male member, would have collapsed. Unfortunately, they didn't have the balls to play those kinds of head games. So at stake here is that Trump not only tried to hide something from the voters, but that he covered up what the payments were in his accounting. And that's fraud. Okay, so presidential immunity fundamentally cannot apply here because all these actions were taken before Trump became president. And the fact that after he was president, he continued to embarrass our country on the world stage and with world leaders has nothing to do with this case. But this is where the typical Trump legal shenanigans start. And yes, I said shenanigans because Trump has the morals of an alley cat. And I'll tell you something else, he's full of malarkey. Now get off of my lawn. Trump's lawyers are demanding that the case be dismissed because part of the evidence the prosecution used, a very small part, includes texts from when Trump was president. That's right, a small part of evidence used against Trump comes from when Trump was president, and the Supreme Court ruling, almost as if they knew, included this important piece, that prosecutors cannot cite evidence involving official acts to bolster other accusations. Now, there is no way the defense can argue that all the other evidence is fruit from the poisonous tree resulting from Trump's texts. But it doesn't matter. That it will twist anything it has to in order to protect the orange blob. It's also crucial to pay attention to the fact that Trump's team sent a letter to Merchan asking permission to file a motion. That's because the deadline has passed to file post-trial motions. And now, every legal step this legal team takes can result in an appeal to the Supreme Court. So they ask to file a motion. Let's say Merchan says, no, deadline has passed. Well, they can appeal that decision and delay. Then the court can force Merchan to hear the motion. So let's say he does, and he denies the motion. Now, Trump's team can take it to the Supreme Court, and the Supreme Court can overrule the decision, and before you know it, the impenetrable state crime is tossed and Trump walks. And that's not even overruling the verdict. The court keeps things solidly on the federal level. And that's how easy it is now to get Trump out of state charges thanks to the Supreme Court. And it's even easier to get Trump out of federal charges. Remember the fake electors scheme? You know, the scheme that directly involves the wife of a Supreme Court justice? Well, Trump's team is definitely going to argue that that was an official act. Watch as Trump attorney Will Sharf tells Caitlin Collins how they are going to argue that the fake electors plot was an official act.
But we believe that if the official conduct, the immune acts in the indictment are stripped away, that Jack Smith doesn't have a case, that this case should be dismissed on that basis. I don't think there's sufficient private conduct here to support the indictment, to support the ongoing prosecution. And that's what we're going to be litigating in front of the district court now.
Even just the false slates of electors, you don't think that would constitute enough for a trial?
Well, we would say alternate slates of electors. And as we argued before the Supreme Court, alternate slates of electors have been a method used by previous presidents, most notably Ulysses S. Grant, to ensure the integrity of prior elections. So we believe the assembly of those alternate slates of electors was an official act of the presidency. That's what we argued before the Supreme Court. The Supreme Court has reserved that issue for determination by the district court, and we'll see how arguments fall in front of the district court.
Yeah, we've walked through those historical references here before. None of them compare to what we saw in 2020 with the fake slates of electors. But Will Sharf, great to have your reaction to this. Thank you for joining us tonight.
Okay, so kudos to Caitlin Collins for providing some pushback. Too bad some of her other colleagues don't know how to do that. But the pushback is in vain, despite its analytical rigor. And of course, the Supreme Court is going to rule in Trump's favor. To rule otherwise would be to leave the door open for criminal prosecution of Ginny Thomas. It's a closed system of plutocratic power, and its fundamental goal is to crush democracy and replace it with plutocracy. And yet, we still have one last vote to stop it. The question is, will we? Will we rally behind Biden? And just as importantly, will we help usher in the blue tsunami to reverse this court's decision? That power is in our hands right now. The question is, will we fight for it? Because believe me, it's a lot easier to knock on doors and drive people to the polls than it is to overthrow the coming plutocracy. And here's how we do it. In 1994, political pundits laughed at Georgia Congressman Newt Gingrich and his Contract with America platform. They joked, "Contract with America? He means contract on America." Yeah, that Gingrich plan swept Republicans into the majority, and no one is laughing about it now. Congressional Democrats, House and Senate candidates can do the same thing now. Only instead of a contract with America, they can run on a supreme change promise in which they guarantee that with a majority, Democrats will deliver three things. First, impeach the two most corrupt justices, Alito and Thomas. Second, expand the court to 13 Supreme Court justices, the same number of appellate courts. Third, enact voting term limits of 16 years on the justices. They still have lifetime appointments. They can still attend and question at oral arguments, but after 16 years, they can no longer vote on decisions. That platform can be a success. Americans are outraged by this decision. It's time for Democrats to channel that outrage into purposeful action, to demonstrate how voting can change this. Turn this corrupt court into a voting issue. The time is now, because tomorrow, democracy is over if you don't. I'm Anthony Vincent Gallo for Occupy Democrats.